Cyber laws are governed differently within and between different countries. What is legal in one country may be illegal in another. It is important to work within the legal boundaries when performing digital forensic investigations in another country, or in multiple countries, in order to keep the evidence obtained as admissible in court. To ensure this, two things must be in place. One, a team that has specialized investigators that are familiar with each country involved, and two, a chain of command through which processes are approved. This way, investigators can have their process double checked by experts, as well as a supervisor, to ensure the evidence is following each nation's rules and will remain admissible in court. In retrieving digital evidence from a foreign nation to be used in a digital investigation, it is crucial to follow the laws pertaining to the country where the evidence is stored, not necessarily where it was retrieved from or what court it will be brought to. For example, if a British or American team were to perform an investigation and store the evidence on our own Canadian soil, they would have to abide by the Canadian laws for accessing and collecting evidence. Again, this is why having specialists on the team is so crucial, as we would rely heavily on them to be up to date and thorough in their knowledge of laws, regulations, and policies in their country of expertise. In addition to this, it is important to recognize that cloud storage privacy and use laws are governed by contracts between the user and the company. Those rules have to be assessed and incorporated into any investigation process, as they too are legally binding. Canada has long been at the forefront of data protection with its Personal Information Protection and Electronic Documents Act, PIPEDA, enacted as early as 2000. PIPEDA protects personal data that contains any factual or subjective information, recorded or not, about an identifiable individual. This consists of not only personally identifiable information such as name, age, ID number, and ethnicity or medical records, employee files, credit records, and so on, but also opinions, evaluations, comments, social status, and disciplinary actions. There are 10 principles of PIPEDA. There are 3 principles that directly apply to data collection and sharing. 1. Limiting collection. Information must be collected by fair and lawful means and must be limited to the data needed for the purpose identified by the organization. 2. Limiting use, disclosure, and retention. Personal information can only be used or disclosed for the purposes for which it was collected, and must be kept solely for the duration required to serve those purposes, unless the individual consents otherwise, or it is required by law. 3. Individual access. Upon request, an individual must be informed of the existence, use, and disclosure of their personal information and be given access to it. Individuals have the right to challenge the accuracy and completeness of that information and have it amended as appropriate. Organizations may deny access to personal data if the information cannot be disclosed for legal security or commercial proprietary reasons, or is subject to solicitor-client or litigation privilege. Canada is and continues to be a leader in the data protection field, and its improvements to PIPEDA will continue to ensure that Canada is set for cross-border transfers, effectively ensuring that Canadian businesses continue to serve European and Canadian customers alike while keeping their personal data secure. Conflict is to be expected when dealing with accessing private information, data, and evidence. It is especially sensitive when dealing with confidential information being procured from foreign nations. Most, if not all, digital forensic investigations will require pulling private data. This is the forefront of the conflict between what is legal, what is private, and the ethics that run between. Most countries, Canada included, have laws and regulations that dictate what data can be used, how it can be used, and for what reason it can be used. This is done to protect both the investigators as well as the users. Investigations and investigators must remain flexible in order to adhere to the laws and keep the investigation valid and admissible in court, thus decreasing conflict. During the international investigation, multiple steps were taken to protect Canada's citizens and interests. A key portion of this was the sharing of information for security reasons with our allies in the Five Eyes Alliance. Notifications were alerted, and the teams immediately identified vulnerabilities to manage. The point of the alliance is to gain strength and security by working together, which is what we did. By helping each other, we helped ourselves. An improved security position for one country is an improved position for the security of the alliance itself. Without a strong security position, we could have impacted and harm the security and personal information of our citizens, economies, businesses, and governments in each country, and ultimately might lead to a lack of confidence in our nations and the alliance. Loss of information, stolen PI, theft of confidential information are all serious losses that an increased security position could prevent.